This is the first time I'm doing this. Welcome to Kingdom Houses Seminar, one of many future ones. The idea is to give out educational material for professional landlords so that they can optimize their portfolio and their return on investment. Each session, I will be having a guest speaker. So this week we've got Maplebrook Wills, who will be talking about trusts and structuring your portfolio in a long-term profitable manner, really thinking about the exit and how that impacts you. To kick off the session, I'm going to start with my own presentation, which is talking about interest rate relief and comparing that against corporation tax and wrapping your portfolio into a limited company. So without further ado, can everyone see the slides?
Yes, sir.
Perfect, we're all good. Okay, so the agenda for today, as discussed, and in the next session, there are a few other things I'd like to tackle, including the extremely exciting new Green Deal from the government. The UK government are apparently handing out £5,000 of energy efficiency improvement vouchers to all landlords. So we'll see if they're true to their word. So, and a little extra, which wasn't going to be in here, but is very relevant, is the stamp duty holiday that's been announced. For those of you who missed it, your standard stamp duty for any purchase under £500,000 is now completely waived. And what this means is if you are a first-time buyer, you can now buy a property for less than £500,000 and not pay any stamp duty. Now, most of my landlords and everyone here are probably professional, landlords already having a property in their name. But it's actually a great opportunity to move an asset from one family member to another if you need to do that. So let's say your father, or let's say you own a few flats around that value, you could move one into your son's name now and avoid that stamp duty hit. And that's valid until the 31st of March. If you're doing a buy-to-let or your second home, the 3% additional charge still applies. But it does mean that there's a discount essentially for buying right now. So we've taken two examples here. You can see if you buy a property up to 500K, first time buyer, £0 stamp duty, versus if you are a second home buyer, you will pay £15,000 stamp duty until the 31st of March. After that, you actually end up paying 30,000. So there's a big jump there. And we've got a very interesting thing with foreign home buyers because there is a new 2% stamp duty coming on top of all the other stamp duties for foreign buyers. And that's coming in place next year, April. So essentially after the stamp duty holiday, someone who is buying from abroad is going to end up paying 5%, which is absolutely massive. You hand the estate agent 1%, you hand the broker 1%, you hand the government 5%, and it starts to become quite expensive. Kindly ignore this line, that's not right. This is just an example showing a 1.5 million purchase and how the stamp duty holiday makes a difference. So if you buy now as a second home, it's 123K stamp duty. And if you buy after the holiday, it's 138. And you can really see that additional margin if you go to the previous slide, where the additional rates start ramping up, starts becoming the majority of your stamp duty tax. What does this mean? It means that within London, you probably want to focus on growth and not capital gains. So you want to focus on income. The capital growth might be limited as the transaction volumes become less. It also means if you're a foreign investor, you could be looking to spend around 10% of the property price on stamp duty, especially when you're buying more than £1 million house. So that will very likely decrease liquidity in the top end range. It also means you may want to consider transferring your property into a special purpose vehicle limited company. So this could allow you to sell the limited rather than selling the property itself, which you need to consider upon proper legal and accounting advice. So yeah, I don't think it's going to make much of a, I think the one thing that's really great about the stamp duty holiday is it's going to offset any drop that we would see as a result of COVID, especially in the range of properties 500,000 or less. So that's a great thing. Some tips and tricks: if you want to buy a very expensive property, you could try to get the seller to split it into flats before the transaction. And this would allow you to actually pay stamp duty based on individual purchases lumped together. So for example, if you turn a £1.5 million house into 3 flats, that's 3 £500,000 purchases, and then you don't hit that staggering 15% rate. Or you could focus on investing in new areas where your purchase price for a new place is around 300,000. Just sort of showing how the UK revenue has grown for tax receipts based on the stamp duty land tax. I don't think that this is a tax that they're going to give up anytime soon. So it's probably just something we have to get used to. Any questions around stamp duty before we move on? All right, perfect. So the real meat that I wanted to jump into is interest rate relief. What is this? What has changed? So you may very well be aware that in 2017, the way that the interest payments on your mortgage get treated has changed. And as of April next year, it's completely phased out, and your interest payments are no longer a deductible expense from your rental received. So instead of it being a deduction, you get a 20% relief on it. Now, that's fine if you're not a higher tax rate payer, because you will pay a 20% tax and then you will get a 20% relief. So for example, if you pay £100 interest on your mortgage, you'll get £20 relief and you'll have to pay £20 tax and the balance is zero. The challenge is if you are a higher rate taxpayer. And I think that most people are, especially my landlords who have property in London. It'd be very difficult not to be one. So, what is the solution here? Here are some 2 examples just showing a big difference. So we take John as an example. He earns a rental income of 50,000 a year. He has his own salary income of 50,000, so he's earning 100,000. And so immediately we know that there's just no way he's going to avoid paying that higher tax rate on half of his income. He will get a 20% relief on the £30,000 of interest that he pays because he's got mortgages on the property, right? So he's got a margin of £20,000 profit per year. But then because of how the tax works, he then has to pay, that 20% on the 50,000, and he ends up paying an additional £14,000 of tax, which means he only sticks 6,000 into his pocket, which is ridiculous. He's paying more in this punitive tax than what he puts in his pocket. If John was retired, so in other words, if John didn't have any income, using the same example, he would stay under the higher tax bracket margin. He would never go above it, and he would only be paying a tax bill of £4,000 because essentially the 20% tax that he pays on his £30,000 of mortgage would be offset against the 20% interest rate relief that he gets. And so he'll only be paying tax on the £20,000 of profit. And in the end, he gets to stick £16,000 of profit into his pocket. So it's still okay for retirement, but if you're looking to grow a portfolio while you have your own income and you're a professional, then you really need to look at a different way of doing it. So what's the plan? What's the solution? Looking at the difference, a massive difference, right? One option is you can just factor the 20% premium against your entire deal and make more money. I don't think that's a great solution. I think that's a very capital intensive solution, and you're leaving money on the table for the tax man. So John gets tired of this. He's like, what am I doing? I've got £500,000 of equity. I'm getting at 6,000 a year. This is ridiculous. So he sells his entire portfolio to Susan. Now, Susan's a smart little cookie. Susan buys the flats inside a limited company, okay? And she does this before the 31st of March. So she saves some money on the stamp duty as well. And because all of her income is now within the limited company, it gets treated differently. It gets treated like a normal limited company. So the entire £30,000 of interest payments are completely offset against the 50,000 of income. And her company shows a profit of £20,000 per annum. Now, she will have a slightly higher accountancy cost because she will have to get slightly more involved accountancy tax return, right? She's not going to be able to do a self-assessment. But in the end, she still makes a £19,500 net profit. She has to pay corporation tax on that, okay? So this is, in the end, she paid corporation tax. And then the way to extract the money out of your limited company is either by paying yourself a salary, paying back a loan to yourself or interest on that, but that's very complex, or paying out a dividend. Now, a dividend is more tax efficient than a salary. So let's go the dividend route. And let's assume that our person is already a higher tax earner. So he's already in the higher income bracket. Now, one great thing is that in the UK, you get £2,000 per year dividend tax-free. So if you don't have any investments paying dividends, the best advice I can give you is just invest in something paying up to £2,000 in dividends, because that is tax-free money. On the stock market, doesn't matter where. All right. So the first £2,000 of that 19 grand is tax-free. The remaining 13,795 gets taxed at the 32.5% dividend tax rate, okay, because it's a higher income earner. So we can see that the combined tax year is still, it's now 50%, but without that interest rate relief punitive situation, the total in pocket is £11,300, which is significantly more than the 6,000 that John was making. And there are some other benefits to having things in a limited company. There's some points over there. I can go into more detail if anybody's interested. Now, yes, the example I picked is perhaps a bit convoluted. Maybe the interest portion of the payments are too high. Maybe a real world example, your mortgage payment would be 30,000, but only 15,000 would be interest. And the 15,000 that is capital repayments will not be tax deductible, whether it's in your personal name or / partnership, or whether in a limited company. What I would highlight is that for Susan, if she doesn't need the cash returned, she's best off keeping it within her company. It will grow the cash within her company by 16 grand almost every year. So that's really the best way to grow the portfolio. There are some other angles you can consider. So let's say that when Susan bought the properties, instead of injecting £200,000 of equity into the company, she only put 100,000 into the company as equity, and the other 100,000 pounds she gave the company as a loan. And now, when she's making this money, she can pay back the loan from her profit. Now, she still has to pay corporation tax, okay? So she's not going to make more than the 15 grand, but she can pay back up to the entire 100,000 pounds in lump sums of 16, 15 grand per year. And so it's quite a tax efficient way of doing it. Bear in mind that if she sells the company, then the difference between the equity she put in and what she sold it for is larger, and she's going to pay capital gains on that anyway. So she will get taxed in the future. But if she exits in the future when she's, for example, retired, she can have a more beneficial tax treatment. So I think that the big thing is that it's, these things are really complex, and we need to look on a per case basis. And also I'd like to say that you should be very careful with loans, because the mortgage companies want to look at your LTV rate when they give you the mortgage rate. So in reality, Susan probably still needed to put in the full equity. And I think this graph, which is not my own, there's a link in the source, really sums up the interest rate relief, which has now fully impacted and is fully in effect from April next year. So we can see landlord A, exactly the same figures, but he's a 20% tax band. He gets to stick £2,888 in his pocket, and landlord B gets to stick about half of that. And again, the example that they've picked here is a bit convoluted. They've played with the numbers to make it exactly double the profit. It's really going to vary based on your personal circumstance. And that's it from Kingdom Houses for this month. I would love some feedback if you would like to give me some after the session once we're done. This is my first one. I'd like to know if this has been helpful to you, if this has been educational, and whether there are any other topics that you'd like to see going forward. I will now be handing over to Maplebrook Wills, who are going to take this a step further and talk about trusts. Over to you guys. Thank you.
Hey, David, could I ask you a question just before you hand over? Would you mind?
Yeah, sure. Shoot.
Just a quick thing, that when you go into limited company or that environment, the interest rates on those mortgages actually can jump quite significantly. At least that's my understanding of it and exposure. Would you agree with that? And therefore, the benefit of some of this is going to be reduced. Whereas if you do it as an individual private landlord, those rates are more negotiable and easier to get on the market. Would that be fair to say that?
I think that's absolutely the case. And that's why the next guest speaker I'd like to bring on board is actually a mortgage broker who does 10, 20 deals per day on mortgages, and he's an expert in the field. Let's start at the beginning. So if you buy a house for first-time buyer private home, that's the one way that you're going to get the best interest rate. And it's a well-known secret in the industry that if you don't own your private home and you want to do a buy-to-let, that you just say, sod it. You buy it as if it's your private home and you rent it out. Now, it's partially unethical, but in the end, I've seen people go from quotes of 1.3% to 3.5%, simply because they don't own a home pre-existingly. So when they get that mortgage valuation done, all of the brokers in the market say, you know what, you're super high risk. You don't even own your own home. We're going to put this massive hurdle. And it's very unfair to professionals in London. There are people earning 100K per annum. They don't have the cash to buy in London. They could easily buy a £200,000 house outside London, and they would like to do that as a buy-to-let. So, you know, that's a personal decision they have to make. That's a massive risk if the mortgage company finds out. You know, the next step for that is, of course, you do a buy-to-let in your personal name, and then you get the slightly worse interest rate. And then slightly more at a premium is doing a limited company interest rate. Now, as a matter of fact, John, the interest rate that I got on my next purchase, which is in the limited company, wasn't that much of a premium. And that's actually why I opted to go that route. Because what I've personally done is I've moved my portfolio from a partnership holding and then incorporated it into a limited company, which is something that HMRC allows for you to do if you operate as a business. And if your purchases were with the intention of running a business. And so that's the route I went. So actually my portfolio, they're all within the limited company at the moment. And we've not seen a massive penalty for that. Definitely the penalty has been, say, £100 a month on each mortgage at most. And the interest payments on those mortgages are £300. So, you know, I'm £40 down because the 20% difference on the £300, granted. But it really simplifies my tax return, and I've wrapped it into a company, and I actually am now able to start looking at other benefits that comes with doing it in the company. All my taxes are nice and tidy in there. I can buy furniture and start depreciating it in a way that keeps it simple for me. And with my goals where I want to go, that makes a lot of sense. And as my personal income is going to grow, I think it's going to become more and more important that I keep them in the limited. That property in question was a 15% LTV. I think I would have had an on-par rate if I did a 30%, 35% LTV. I hope that answers your question in full.
Yeah, good answer. Thank you.
You're welcome.
And if I could, I just sort of just step in just to bolster that. It with the last case we were involved in, and I'm not a mortgage broker, I'm a tax and trust advisor, but the interesting thing, and you've already said this in your speech that you've just done, is that the important thing is the bigger picture. Now, on a case-by-case basis, this particular landlord, he switched his mortgages over to limited company mortgages, and his accountant did the calculation. And within a year of switching up to a rate that was 0.4% higher than his current rate, he would be saving money because of the ability to offset the mortgage interest. So there's an initial hit, absolutely, on an increased the premium on the mortgage. But the long-term savings, just on the ability to offset the mortgage interest alone, in that particular case, didn't take long to kick in. And then, as you just said at the end there, which I know Mike and I are going to talk about, having the properties in a limited company moving forward provides so many other tax benefits that I think the initial hit of a higher premium on the mortgage soon pales into insignificance.
Well said. Can't argue that.
Well, Mike, you guys take it away. I think I've made you guys co-hosts so you can share
Okay.
your slides and run with it. Perfect.
So what I'll do is I'll put up some slides, and can everybody see professional landlord planning? Cool. All right. Well, thank you very much, David, and We appreciate the opportunity to come and talk with you. I'll whip through a couple of slides here. We'll talk about some thinking about estate planning in relation to taxes, and Dr. Paul is happy to take questions and do a Q&A. We'll just buzz through it. We'll talk for a moment about us. We'll run through what the real problem is, talk a little bit about IHT and some trusts, and start to look at solutions, and then where does it go from there. I'm Mike Pugh. I'm a professional estate planner and will writer here in the UK, born in Canada. Was named top will writer in the country for a couple of years in a row within New Leaf. I've got about 40 will writers now in the country. And it's my great honor and privilege to be able to introduce Dr. Paul Hutchinson, a man who probably doesn't need any introduction because he was in the Parliamentary Review in 2018, so the whole country got to see him. Paul's been a professional estate planner and will writer, as well as being a commercial solicitor, lawyer. He's a doctor of law specializing in estate planning and taxes and trusts. So we're not afraid of complexity or size. We've kind of got that covered. So what is the problem? And the problem is really kind of basic and straightforward. The problem is, frankly, most landlords give away half of what they've got when they die. Pretty much half. Not quite half, a little less, but or a little more depending on the combination of various taxes. And I can guarantee you nobody's worked their entire lives so they can just hand half of it to the government just because they pop their clogs. That was never really the plan. You must remember that what we do is called estate planning, not estate panicking. Spoiler alert, if you don't know what's coming, I'm sorry to be the guy to tell you, but it gets dark at the end of the story. And therefore, the second part of the problem most property owners face is not knowing what to do in relation to how to avoid giving away half of their estates. They start to sell down their estates as they age. That just crystallizes some large cap gains tax issues, often meaning they then have to sell more properties to continue to maintain those payments and get those tax bills paid. Inheritance tax. Everybody has some familiarity with this, I'm sure. It is probably the single largest tax in the UK, and also, strangely, the only one that's voluntary. And I know you're probably going, what on earth does that guy mean? How can it be voluntary? Well, it's a very simple metric. Either you plan for the fact that you've got an inheritance tax problem and therefore you don't pay anything, or you volunteer your cash. And so it is something that you can mitigate with just a little bit of planning. So IHT is predicated on domicile status, your domiciliary status. So an individual who's domiciled UK is going to be subject to IHT on their worldwide estate. An individual who's not domiciled UK is subject to their IHT only on their UK estate. When is IHT charged, inheritance tax? Well, everybody knows that it's charged on death, but it can also be charged in lifetime on chargeable gifts, gifts over £325,000. It can also be charged when you put properties into a trust under a relevant property regime. All these slides will be given out to everybody. The rate of tax, well, if you are below the £325,000 nil rate band, the tax rate is effectively zero. This nil rate band is transferable between spouses. So married couples, civil partnerships have a £650,000 allowance, and they can pass that $650,000 on to their descendants and pay zero tax. Anything over $650,000 for married couples or $325,000 for an individual is going to be charged a rate of 40%. Okay, and if you do a gift, a chargeable lifetime gift, the rate drops to 20% immediately, and then you get taper relief on the balance over 7 years. Everybody's kind of heard of the 7-year rule. And for estates where there's a 10% more gift to charity, you can get a reduction in your IHT rate of 10%. In 2015, there was the introduction to a new tax regime, a new tax break called the residential nil rate band. And we'll just flip forward, here it is. And that is, as of today, £175,000 per person if you own a principal residence and you leave that to your lineal descendants. So a married couple, in essence, with a dual RNRB would have £1 million inheritance or an inheritance tax relief. And then anything over £1 million would be taxed at the rate of 40%. So it's pretty basic stuff. We're just going through this fairly quickly. IHT, you can get taper relief on gifts of basically, if you give a gift and you die within 1 to 3 years, it's as though the gift never really left your estate for the calculation of IHT. And then from there on, it reduces by 20% per annum up to 7 years, and then it's considered estate. There are certain issues specific with legal services in relation to providing professional services and advice. Quite clearly, there's often a gap in knowledge between the professional and the client, and that can put the client at a slight it also, because we're will writers and estate planners, we're often finding that we're being called into a familial situation, a great deal of difficulty and stress. People are not doing well physically, mentally, inabilities. It's also very hard sometimes for clients to judge the quality of service that they've received. They get various, if I'm not going to go up against, that'd be insane, I'm not an accountant. But if they can do your self-assessment tax, great. But that doesn't necessarily mean they're qualified to give you specialized advice on various bits and pieces. I don't go to a general practitioner or a doctor and expect him to be a surgeon. I don't see my barber and expect him to fix my car. And people get confused. They think, oh, well, my accountant said I should do X, Y, and Z. Yeah, but they've never done it before and they have no idea what they're doing, is the simple retort. And that can cloud the issue for people. Whereas Dr. Paul and myself spend every day, all day, these issues. Trusts. Let's talk about minutes. What is a trust? Well, trusts are not necessarily new. It's just most people don't understand them very well. They're opaque. They don't report generally. They've been around for a great deal of time, over 3,000 years. They were first mentioned in the Iliad. The Romans brought them down, and it was the Crusades that really codified them under King John. According to the Oxford English Dictionary, a trust is an arrangement whereby a person holds a property as its nominal owner, or also titular owner, for the beneficiaries. They don't actually benefit from the utility of the asset. That's on behalf of someone else. So a trust allows the use of assets for someone without giving them ownership. Go on for another person. You can allow trustees to make decisions as to who and should benefit from the trusts. Should you want to have an unequal distribution? Unequal distribution, it's your trustees. That's very helpful for a lot of high rates. And allows trustees to manage the assets on behalf of the beneficiaries. Okay. I've got the speaker. Is that any better? Okay. So there are three principles within a trust. There's a settlor, there's a trustee, and there's a beneficiary. Settlers are the people who settle a trust. The proper name for a trust is called a discretionary settlement. Trustees, clearly, Trustee Act 1925, Section 14, Law of Property Act 25, Section 27, Section 2, defines that they are the guardians of the trust and you need to have a minimum of 2. Beneficiaries ultimately are the people who benefit from the trust. There are 2 major types of trusts here in the UK. There are trusts that can be created within the will that you have written. These trusts will only become effective once death has occurred because by definition, a will only becomes effective once there's a death. The other type of trust, the ones that we're going to be looking at here today, are called inter vivos trusts, or trusts that are set up inside of life whilst you're alive, meaning you also get to enjoy the benefits of them. So an inter vivos trust is a discretionary trust, usually where the settlor has the exclusive right to benefit from the assets held in trust during his or her lifetime, and after his or her death, the assets will be distributed to the remaining trustees, by the remaining trustees to potential beneficiaries, in accordance with a non-binding letter of wishes. So why trusts? What do trusts actually do? Well, 45% of most marriages in the UK, if assets are in trust, generally they can escape past the divorce courts because plaintiff, they never entered into the marriage contract. So if you left assets in the trust and your children became the beneficiaries of the trust after you passed away, Mr. and Mrs. Wrong doesn't get their hands on your money that you left to your children. Trust. Bankruptcy. Your kids start a restaurant and after you've passed away, they've received your property gifts, trusts. The creditors show up because the restaurant fails, but the creditors don't get their hands on your monies that you've left. Again, the ring fence from predation of all sorts. Remarriage is quite only because people don't like to think about this stuff, and that ceases the other mourns, and then, you know, humans are social animals. She goes out, he goes out, gets remarried. They marry the younger model, right? And then, you know, humans are social. That's what they do. They predecease Mr. and Mrs. New, and now everything's going to go out the door to Mr. and Mrs. New, and nothing's going to go down to the children of that first relationship. Not because somebody's scheming to get their hands on your properties 20 years later. It's because people don't like to talk about this stuff. Talks about it, it just happens. High net worth. Do you really need another $1 million, $2 million, $5 million, $20 million arriving into your children's estates? Absolutely, creating a taxable charge when they die 50 years from now, meaning the government's going to take another 40%. Probably not. Living abroad, you don't understand different tax regimes in different countries, different legal systems. Having your assets within trust inside the UK, protected under law. And means assessment. Maybe you've got a child, maybe you know someone who's got a disabled child. Money appeared in their bank accounts, it would be gone instantly as the local authority would retool their assessments. Wouldn't it be better to have those assets in trust so that way the child continue to have benefit, and with the assets in trust, enjoy the utility, meaning they could upgrade their lifestyle perhaps. Inter vivos trusts should always be set up well in advance of their need. It's called estate planning, not estate panicking. We get calls every day from people where they've left it a little too late, and that's on. But when it's done correctly, you can basically protect the principal private residence from all of the previously mentioned threats and your other properties as well, which is what we're here to talk about. Very briefly, a GROB sounds weird. Gift with a reservation of benefits. Some people say, well, I'll just gift the gift. I'll just gift the properties away to my children. That, you know, that'll be fine. We would encourage you to think otherwise. What if your child dies and left it to their spouse in a will and you never got on with your in-law? Now they're in control of the gift you've left. If you've gifted your principal residence to a child and they had a financial hardship and the creditors show up and throw mom or dad out of their property, it's just a peril. It's just all kinds of moving parts to this that really honestly go wrong. And I'm not making it up or trying to sell you something in the traditional sense of pitching doom and gloom. It's just I do get calls on this every, you know, golly, probably once a month, once every 6 weeks, somebody tell me the hardship they're undergoing because they didn't seek professional advice prior, and it all went pear-shaped. And then they're scrambling to get some good advice. So those are, it's just a whirlwind because I'm sensitive to time, and I know that he wants to do. So what's the solution? The solution ultimately, if you're a professional landlord, is what we call professional landlord planning. Dr. Paul puts all of this together in conjunction with Maplebrook. Bring your IHT from 40% down to 0. We can bring your capital gains down to 0, and stamp duty goes to 0. That's pretty cool. No gimmick. It takes 3 years. There's no shortcut, I'm afraid. Step 1 is that we would formalize a partnership. When you formalize a partnership, and you can do this with less than 4 properties. If you had 3, but you knew you were getting another sometime in the next year or so, you can get this ball rolling. It's going to take a year, but it will ultimately wipe out stamp duty. There is no stamp duty to be paid. Step 2 is we obviously incorporate, as you're familiar with this, and you want to move the properties into the corporation. And the moment you do from a partnership, there's no CGT to be paid. Pretty clever. And then step 3 is you form a trust. It's a special type of trust, a Section 86 trust. This would be immediately after the 2 years of forming the incorporation. And this, of course, wipes out your IHT liability from 4% down to 0. So in essence, if stamp duty were 5% for easy math's sake, we're, and making up numbers, we're removing about 68.4 tax burden on estates. And the evidence is clear, and Paul and I have run a number of these cases. One of our more recent cases was a client in 20 properties, total estate value, total, everything, about 8 million. So clearly there's an IHT bill there. It was about 1.5 million, and there was an inheritance tax bill of about 2.8. So there was a tax liability our client faced of 4.3 million pounds, a little over 50% once it settles. Nobody's worked their entire lives just so they can break off half of everything they hand to the government just because they passed away. That's nuts. Nobody does that. So they had gone out and consulted a couple of different firms. Paul will tell you the names of them. What these other firms will charge, they'll do the same thing we do. They'll charge you 10% of the savings. And so for 430,000 pounds, they'll do the work. Seems reasonable. We'll do it for less, you know. I'm not trying to say that we're cheap and easy, but we sort of are. And that's because we're in Bristol. We're not subject to London prices. We pay the overheads you guys pay. It's a nicer lifestyle outside of the big city. I've lived in big city Asia for most of my adult life. We're a city. So this is the whirlwind tour as to what we do. I'm pretty sure everybody's going to have a ton of questions. In congratulations, or in wrapping, now what does this mean? Well, quite literally within 5 more about professional landlord planning than 95% of all of the landlords. What they will do is just start crystallizing CGT by selling down properties towards end of life because they don't have a plan. We can help you avoid losing half of your life's hard work, half of your life's graft. If you'd like a free fee, happy to do it. We won't even charge you the 3,500 pounds most other firms charge for the feasibility study. Just give David a call or give me a call. Here's my number. That was Whirlwind. That's us. So I hope that was helpful. I'll leave that up if you want to write down David's number. I'm pretty sure everybody's going to have David's number. So I'll stop the share there and we'll let the questions roll. Was that? It's also Friday and I'm pretty sure nobody, but hey, it's taxes and it's Friday. The headwinds are pretty big on this one. I'm just going with what I'm given.
I think it was great. Thank you very much. I learned stuff that I didn't know before because I know that I'd read your brochure, but going through the 30-page slide, not something I do at my own time. So yeah, let's open the floor if anyone has questions for Mike or the team.
Well, David, I've got a question, if that's okay. I think, Mike, that you raised a very important point, that you made a number of serious, really important points, one of which was you said, it's hard to judge the quality of the service received. And that resonates with me because I have actually had contact with 1 or 2 or even 3 people in the past. And I'm afraid I haven't felt confident that my best interests were part of the whole process. In other words, I did feel that the fees that they were going to receive far away were more important to those giving advice. Now, I know that sounds a bit severe and I don't quite mean it or mean to express it like that, but judging the quality of service and the likelihood of a good result, you've almost covered it by saying there's a free feasibility study. I did understand that. And that I have in contact one particular group and they wanted to charge quite a lot to just review what I have and what we have in terms of planning. How would you answer that? How do you judge the quality of the service received? Because I think that's a really important area. And it's one in which I've got some friends that have been badly put off by presentations that they don't really believe. How do we deal with that?
Well, first of all, if it'll make you feel more comfortable, I am always happy to charge you for the feasibility study. I don't want to reduce your expectations being in London. I wouldn't want you to feel put out somehow. I'm currently looking to hire people and I've got about 40 resumes on my desk. The answer to your question really, and because I have a high intuit level, is it often comes down to gut feel. I've sat in rooms, you know that you're the prey. You just know it. They're looking at you and the meters are. What we do is we charge a flat fee. It'll be up front. It's in the window. It's a fee that gets broken up over 3 years. We don't ask for all the monies up front even. So it really is a question of making sure that you have the comfort from the level of knowledge and the capability, and that you have a better term. Your gut feel is these guys are on the level. You know, if it's of any use to you, John, and I say this with comedy, it's also the truth. I know what's going to happen if weird happens, and that is the guy with the funny accent, the Canadian's going to get in trouble because, you know, I've got 2 kids in school and I'm not prepared to cause any problems. And for the record, I wouldn't have been able to attract the types of relationships and support that Maplebrook has. And I make clear reference to our celebrity du jour and Dr. Paul, who a good friend of mine, and now appreciate him being in attendance today. In fact, Paul, you might be able to add to some of this because you've had far more experience than I in relation to this type of a question.
I think it's a really good question. I mean, as you say, I've been doing this 20 years and I've worked with a number of professionals in the tax and trusts arena. And I think this might sound counterintuitive, but the reason I work with the team I work with is because one of the questions that people always ask is when you present a piece of planning to them, as they say, is this going to work? You know, can you guarantee the HMRC aren't going to come sniffing? Am I going to be able to put my head on the pillow at night? Now I can answer that last question, and it's yes. But to me, I've come across far too many people that have said, yes, it's going to work because they've provided, not necessarily, they've been very clever, haven't said it's a cast iron guarantee, but they've given you these, I think, very unreasonable expectations. Yeah, it's going to work. You know, I've been doing this such a long time. And our approach and the team I work with approach is that we're not doing anything wrong. What we're doing is we are doing this, but we are going to put you in the best position with the best advice. And one thing we can guarantee you is that the advice and implementation we're not giving you is A, incorrect, and B, negligent or fraudulent. If HMRC choose to raise questions, which they are entitled to do, then so be it, but we'll be there to handhold and deal with them. So to me, it's saying to a client, whether it's just basic trusts that Mike's gone through earlier, or what we do, we never even give percentages, or we never give guarantees, or we never say this, because it's not, you're sat there, and when you're dealing with HMRC, and you're dealing with someone who's got out of the wrong side of the bed. You're dealing with someone who is looking at this with a subjective slant on what should be an objective test. And so pointing out the pitfalls, pointing out what the negatives are, you know, even David did on his presentation, the downsides of going into a company, pointing out both sides. And that's what is important to me, and has shaped the way I work, is not just saying this is great, this is all the benefits, and just we'll push the negatives under the table. It's just being honest, and sometimes being honest is also talking about the negatives. And sometimes being honest, clients will walk away. But if that's the way it needs to be, then so be it.
Okay.
I've been honest in the last business, but I've also been referred by the people who didn't do the business with me because there was another piece of business that somebody else needed, and it wasn't germane to that piece of business, but they just liked the fact that we're an honest dealer, and then business out of it. So, yeah, it works.
Okay.
John, I think it's worth it for me to mention. I haven't used Maplebrook's service myself yet, but we're in the process of looking at. And no, Mike is a very slick-looking silver fox, beautiful hairline. I wish, you know, when I'm his age, that I look half as good. But I think
give me my wife's phone number. Make sure you tell her how good that.
Yeah. At the end, you know, the introduction that Kingdom is making is a big risk for Kingdom. You know, I'm introducing them to over 40 landlords. And this is a slow process. And I think that they're well aware that if they screw over one of my landlords, you know, that's going to come back to the rest of the landlords well before the other landlords enter into business. I think that it does follow on to my next question, which is whether, you know, at what point does the service become cost effective? If it's 130K / is there a lower cost route depending on a per case basis? You know, I think there needs to be a cutoff. It needs to be worth it. But the reality is, yeah, if they don't look after you, they're going to lose other business from Kingdom. But also very much I agree with you. You need to be buyer beware, and we definitely need to feel these gentlemen out. I've sat into 2 of their in-house team meetings and listened to them discuss sort of legal changes and things that come up, and how they've said, okay, we need to reach out to the clients and make sure that they're covered for this difference and that difference and modify that. So I think that they have the right attitude, having had a little bit of an inside scoop there. But it's a difficult product to assess. You know, we're not buying an ice cream, and we're not buying a car that's got a 10-year lifetime. And I know I totally understand your concerns. As far as I understand it, the entire process is completely legal. You're allowed to transfer the assets like this. There is always the risk that new legislation goes, okay, moving forward, we're taxing trusts, or moving forward, we're doing this, you know, tax-wise. Looking back at John, you know, let's say that John bought that portfolio before the interest rate relief changes, you know. John didn't plan on that 20% relief and having to pay taxes on his interest payments. You know, he bought the portfolio 15 years ago. But one thing that the UK government seems to consistently not do is they don't retrospectively change things and then retrospectively say, well, now that we've changed it, anyone that exploited it before are going to get penalized. And I think it's one thing that I like about the country. Granted, I'm quite a young citizen of the country, so again, take that with a grain of salt. But whatever you do choose to go with in the end, please keep me informed so I can make sure that that everyone's looked after. So Mike, the question is, at what point is your service cost effective if we're talking about 130K cost?
That was just an example. That's cost effective for that particular barrel of a bill of 4.3 million pounds. So this is where the math really works out. You're going to pay, like, let's imagine here, David, you've got, pick a number, 6 properties, you've got an inheritance tax bill and CGT tax bill, combined bill of, I don't know, 800,000 pounds. Well, that's going to happen. That's a fact. There's no really wiggling out of that unless we do some effective planning. And then I've had cases where we've charged as little as 65,000 pounds for something. Like the price scales only based on the number of properties that we're dealing with, and any outside complexity. So if somebody's got 4 properties, 6 properties, certainly it's a much lower premium or in these problems than somebody's got 20 or 30 properties.
And to clarify, I know from your website and from the conversations that we had is that you guys also do normal wills, you do the other things as well. If we have a landlord that says he's happy with his assets, but actually his will needs refreshing, he doesn't like the guys he's doing business with, he's never seen them, you guys can also help with that, right?
Oh, 100%. Yeah, we don't just have to go for the biggest deal that we do. We do wills, lasting powers of estate, funeral plans. We do basic trusts, vulnerable beneficiary trusts, you name it. That's we do the full spectrum of estate planning, and can help everybody. I
think the one thing that I wanted to mention about putting your properties into a limited company, now it is a small thing because you do have public liability insurance and buildings insurance. But one thing that's interesting is it actually creates another liability barrier between you and your assets with regards to your tenants and guests. So the nice thing there is if you get sued, it's the limited company that's going down. Unless there's criminal negligence on part of the director, you create like another barrier for that. And I think that's a very interesting to point. So by putting things into a limited company, I know it's not strictly got to do with trust, but into a limited company, you kind of create a firewall in both directions. If you go bankrupt, the trust can protect your limited company. If the limited company goes bankrupt for whatever reason, you can protect your other assets. And I think that it's an interesting way, but it's going to depend a lot on where my landlords are in their life and in the cycle of investment and using up the assets, which route they want to go and what's going to work. If anybody has more questions, the floor is back open.
Can I just pick up on something that you just said earlier, David? It's just that about legislation being retrospective, and having worked at parliamentary level with the Legal Services Board, it's just interesting, and I'm sure this won't come as any surprise to you, but the legislation makers don't ever want to shoot themselves in the foot. And you've got to remember that the legislation is being made by MPs and Lords, or being passed by Lords, all of whom have property portfolios. So are they going to bring in legislation that is, if it's retrospective, will undo all the planning that they've done themselves? And the key thing when people say, does sort of planning work? If you don't already know who is the beacon for this sort of planning, who's done this, then I will tell you that it's the Duke of Westminster, the Grosvenor estate. So Eaton Square Properties Limited is the, well, now Hugo Grosvenor, obviously, when Gerald died 4 years ago. But Hugo Grosvenor is now the main beneficiary. The Eaton Square Properties Limited own all of the properties within the portfolio. The Grosvenor Trust owns the required shareholding of Eaton Square Properties Limited. And so when Gerald died in 2016, and if you don't remember, you can see it all over the internet, there was huge hoo-ha made. Duke died with 9 billion estate and doesn't pay a penny of inheritance tax. And, spoiler alert, the reason he didn't pay any inheritance tax was not because he'd done something really clever or he was avoiding tax. he had everything set up in this sort of structure. So when you've got the Duke or the Grosvenor family who've got a 9 billion estate holding their properties in a company and then the shares in a trust, you know, it's going to take something incredibly special for government to pass legislation that goes back to Boodle Hatfield Solicitors in London, where I did some of my training, which is why I know this, for them to say, sorry, you're going to have to unwind that and pay all the taxes. So it's just worth remembering, if it's good enough for the Grosvenor family, then it's good enough for us mere mortals who don't have 4,500 properties. It works, you know, right from the top through the different levels.
Thank you.
If anybody is interested in having a further conversation or is curious about what it is that Paul and I are getting up to, Paul, would it be okay if we invited them to sit in on a Tuesday evening trust talk? David, is that all right? What happens is every Tuesday night at 6 p.m., we hold a trust talk and we talk about all things trust, and it might not have anything to do with property and other elements, but we do that every week. And we end up with and we had one today at 1 p.m. I think we had about 19 people on of the 40 odd will writers that we have scattered around the UK and overseas. And if you wanted to get more of a feeling for what it is that we're doing at Maplebrook and with Dr. Paul, I'd be happy if you wanted to sit in and kind of catch what we're doing.
Yeah, that's fine. If you want to send me the link, the details, when I send out this video to all the landlords, I can include it in there in case anyone that's watching the video later. Okay, guys, I think it's time to bring the session to an end. It's been really, really informative, in fact, and I hope it's been interesting for everyone watching. Anish, I will just caution against doing partnerships with random family members or friends. One has to be very careful not to lose more than the capital gains tax that you could pay. And I would like to thank Mike and Dr. Paul for their attendance and for those of you that came. And I know that many are going to be watching this once the video